Listen to the voices of the advocates.
Welcome to Advocates, the podcast. After departing a career in accountancy, Harish became one of the youngest advocates to be appointed senior advocate at the Indian Bar in 1992. Harish has had a fascinating career largely at the Indian Supreme Court Bar and rose to be Solicitor General of India. Intriguingly, after finishing his term as Solicitor General, Harish began a career at the English Bar and took silk just a few years after his call there. I have little doubt that you will be absolutely captivated by his story. We at Advocates, the podcast, are delighted to bring you Harish Salve QC.
Good morning, Mr. Salve. Thank you for joining us today. We'll start with your background, please, sir. We've done a bit of reading on you, of course, and I've discovered that your grandfather was a prominent criminal lawyer and your father was a politician and was a member of the cabinet. Your mum was a doctor. How important was your family to you in relation to how you ended up now as a Queen's Counsel practicing in England?
Well, I think in India and in Asia, as in fact, most of the world, your family influences you a lot. I grew up in an ecosystem full of professionals. So my father, in my younger days, I remember my father more as a practicing accountant, and he had a very large accounting and tax practice. And then he became a member of parliament, and for years he was a member of parliament. In fact, in all my formative years, he was just a member of parliament and a very successful tax specialist. And that's where I first cut my teeth, working with him, learning tax law, and that's why I became an accountant before I became a lawyer. And my mother was a doctor, but one great influence on me, I mean, I never saw my grandfather. He died 3 months. My paternal grandfather, he died 3 months before I was born. But I saw my maternal grandfather, who was an architect, and he was quite a prominent architect working for the British government back in the day. And he was passionate about reading and about acquiring knowledge. And I think I was very attached to him, and he inculcated in me the habit of reading, the curiosity, intellectual curiosity. So that's the ecosystem in which I grew up. My mother's younger sister, who lived with us and who virtually nurtured me when I was young, because my mother was busy as a doctor. She was herself a professor of philosophy in the local college. So we grew up in that ecosystem full of professionals, full of education, full of study, and that has been the beginning of my journey. That has been the road of my journey, and that's what's got me here.
Interesting you say that, because yes, of course, you grew up in this I suppose professional milieu. Did you at any time when growing up consider a career in academia, for instance, or was just always you going to be a professional one way or another?
No, it's a very interesting question you ask me. When I turned 40, and that was a while ago, 25 years ago, my father asked me
Yeah.
whether I would consider joining politics. This is, we are still talking of 1996. My father had just come out of parliament. His political party was keen on getting me to join them. And I said no. And he told me, you're doing very well. You've been a silk for 4 years already. In India, I was made silk in 1992 January. So by 96, I was already 4 years silk, 4.5 years silk. I had a very large practice in the Supreme Court and the High Courts. And he said, you're only 40. By the time you're 50, you'll get bored of this. And by the time you're 55, you'll regret not having done anything else. So why don't you think in terms of joining politics? And I told him, no, if I know at some point I will want a change in life, because you do get bored of the same courtroom and the same kind of case and the same brief and the same argument. I said, I will most probably join academia. I will happily earn money
Ah,
and then go and maybe buy myself a house somewhere outside Oxford or Cambridge if they agree to have me, and be a guest lecturer and study constitutional law, read constitutional law, lecture on constitutional law.
I see. I'll come shortly on the constitutional law angle because obviously you did a couple of huge constitutional cases. But before that, could I just ask about your relationship with your dad? Because I saw an interview you did where you openly told the interviewer that when the emergency was declared by former Prime Minister Indira Gandhi, you openly disagreed with him with respect to the emergency. I think you used the word you were disappointed that he supported the emergency. You, of course, even at such young age, was quite a opponent of it. How
So
did your father take that actually?
1975, 19th of June 1975, emergency was declared. And that was quite a turning point in my life. We were a group of friends. One of my friend's father was an eminent senior counsel. Uh, that friend, incidentally, retired last month as Chief Justice of India. So we were all in the same group of friends, and we were all of us, our whole university, I would say, barring few who had political affiliations, were all against emergency. Believe me, the whole of India was against emergency. We all knew it was only a ruse to create a system in which the prime minister of the time would not be unseated and so on. My grandfather was a very successful criminal barrister, and he was being offered in those days the post of public prosecutor. In those days was the stepping stone to advocate general, and very big. And I'm you're now talking of late 1930s, and he refused that, and he joined the freedom movement to the extent that in 1940s he went to jail, and that's where he lost his health, and that's why he died
Mm,
in that sense relatively young in 1956. And when he came out, he was a member of the Constituent Assembly. He was on the Minorities Committee, of which drafted the articles relating to minority rights in the Indian Constitution. He was very active in the Constituent Assembly. I told my father that the values for which my grandfather's generation stood for, and they gave up their lives, as it were, they gave up all that was dear to them. And I told my father, I said, look at how you suffered. You were a family of 7 or 8 children. Those days, people used to have large families. And my grandfather and grandmother were both in jail.
mm,
So the whole family was in disarray. My father lost two siblings to just ill health because there was nobody to look after them. And I said, that's the sacrifice my grandparents made to achieve what we have today. How could you have gone and voted against it? So that was the sharp difference. But after which, it was the turning point, because after which I have always had views against his political affiliation with the then ruling party. And it reached a head when I became the Solicitor General in 1999, when for the first time his party was out, somebody else was there.
That's right.
It
Was
was,
that
it
particularly
was,
sensitive
he
that
was
period,
deeply
you and your
disappointed
dad?
because
Uh,
he told me, you've promised me you would go from law practice to academia. Why are you getting into this? And I said, look, unlike the UK, in India, the Attorney General and Solicitor General are generally top lawyers. They are not appointed because they are members of parliament. So we don't have a political role. In fact, Solicitor Generals never are members of parliament. The Attorney General also has never been a member of parliament in India. He has a right to address parliament under the constitution, but he's never a member of parliament. So joining, and I personally felt that coming from a family that was from the Congress party, if the first BJP government made me a Solicitor General, that was testimony to the fact it was not dynastic politics, it was on merit.
ah, yes, yes, yes. I see the point.
And I must say, yeah, it was a wonderful opportunity to work with some very wonderful people.
Right. Mr. Salve, you told us earlier that you started out becoming a chartered accountant. So And I read, of course, there was a particular opinion or advice you rendered, and which took the attention of Mr. Another boy Pakiwala, who advised you after reading your particular opinion that perhaps you ought to consider a career in the law. Could you tell us, our listeners, a bit of how that happened?
Oh, that was yeah. So the year is 1975. I had just finished my graduation. I was in second or third year article clerk, but I had joined articles much earlier, much before my formal registration, from 1972. So I was quite a senior as an article clerk in the office. My father had headed a committee in 1973, which was called the Direct Taxes Committee, and they had suggested some far-reaching changes to the tax law. One of them related to setting up of what is called a settlement commission, where you could go and settle contentious assessments.
Mhm.
And his partner in Nagpur asked me to make a note on whether a particular one of our old clients, whether he could have availed the benefit of that. And I read the section and I felt maybe he could.
Okay.
So I wrote up a note. I wrote up that note for my boss, who was my father's junior partner. And he suddenly at 3 in the afternoon, I'm told, please come, you'll be called for a meeting. My father was visiting Nagpur that time. He was mostly in Delhi. The client is here and you're called for the client meeting. Now, as article clerks, you don't do client meetings. So I went there, and my father's partner shoves that note under my father's face and says, "This is the note you asked us to prepare." And I was petrified. My heart was in my mouth. I was, and my father read that, and my father could be quite intimidating. And he just looked up and said, "Who made this note?" So my father's partner threw me under the bus, and he said, "He made this note." So my father looked at me and said, "I drafted this section. It never struck me this is how it could be interpreted. Well, you seem to be right." But he says, "These stakes are so large, I would like to take senior counsel's opinion." And he says, "The reward for the good work you've done, you will be part of that meeting." That's how I ended up in Mr. Pakiwala's chamber in Mumbai. And he read the opinion and he looked, and my father very proudly said, "Harish has done this." He looked at me and said, "When are you joining the bar?" The die was cast.
Oh. There was no turning back then. So you working with Mr. Pakiwala for a number of years?
No, I had an opportunity to work with him. He was not in day-to-day practice. He had, by which time, turned mostly to corporate work. He was working. He had become part of the Tatas, but he used to come for big
Oh, that's
cases.
right.
In 1970, he went away in 1977 as ambassador to the US. He was there
Mhm.
as an ambassador for a year. He came back in 1978, and he came to argue the what is called the second fundamental rights case, where the constitutional validity of the 42nd Constitution Amendment was put in issue. It was a pro bono case, and I had just joined Dada Chanji and Company. There were two youngsters in Dada Chanji and Company,
Mhm.
and the senior most partner who was looking after the case, there was no billing involved. This was all pro bono work being done. So it went right down the food chain, and we were
I
two of
see.
us were told to assist Mr. Pakiwalas. So we did a lot of research and we helped him. The other youngster who helped him, incidentally, is today known as Justice Nariman. He's now the second senior most judge of the Supreme Court.
I see. would,
The
would would this
Minerva
be
Mills
the
case. So we
Minerva
did a
Mills
lot of
case?
research. And Mr.
Right.
Palkhiwala was very happy with the work we put in. Then in 1980, we did another very big case together. In between, I went for a couple of matters. Clients would engage me to go and take his opinion. In 1980, I moved out of Dada Chanji and Company. I joined Mr. Sorabji's Chambers, 8081. And
Mhm.
then also, we continued to do cases together. So I've had the privilege of working with him in a number of cases.
So Could I just now ask Soli Sorabji, who later became the Attorney General of India, how big was his influence on you, your
Huge.
career, your development as an
Oh,
advocate?
huge, huge. I mean, solely fashioned my thinking, solely fashioned the way I work, solely fashioned my mind. I joined him when I was raw youngster, 1980, 81.
Hmm.
Learned some very important things from Soli. Learned the first thing I learned from him is, however senior you may be in the profession, you're always a student of law. Don't ever think you have mastered the law. You're always a student of the subject. The second thing I learned from Soli is always think on first principles. Don't try and develop a case from precedent to precedent. First, develop your case on even Mr. Pakiwala. First, develop a case on principles. Think on first principles. Third thing I learned from him is the devil lies in the detail. Master your case, master the facts of your case, then think in terms of law, and then think in terms of precedents. The fourth thing I learned from Soli was you are a salesman of ideas. An advocate is selling an idea to a judge. You have to sell your idea at the same time. You can never offend your customer. So always try and read the court. Because if your object is to put across a point of view, you can never do it forcibly. It has to be persuasively. And Mr. Palkhiwala's great quality was he could make the point seem so simple that a judge would feel that if I don't agree with him, I will look like an idiot. Now, that's the secret of advocacy. Never complicate your point. And I once asked Mr. Palkhiwala, and he said he learnt it from Churchill. Churchill's most powerful speeches were so simple to understand and yet so powerful. So that was Soli's tradition. You have to simplify your case. You have to tell the judge, my case is so simple, and this is the only way you can look at it. That's the secret of good advocacy. And always read the court. Always read the court. And finally, I learned from Soli, especially when you're arguing important principles of law, be it commercial law, be it constitutional law. A judge sitting there, especially a judge of a superior court, a court of appeal, or a Supreme Court, his perception is much beyond your case. You're asking him to lay down law. You're focusing on the relief to your client, and through the narrow tunnel vision of your case, you will never connect with the judge. When you're making a submission on law, look at the bigger picture. Does this fit? Does it make sense? Is this what is going to be in public good? Be it commercial law, be it constitutional law. If you cannot put that mind frame, and if you're not in that mind frame, you will never connect with an intellectually powerful judge.
Wow.
I see.
Yeah.
Well, that was some exposition. Mr. Salve, when as a young advocate, though, of course, you were junioring Mr. Sorabji and then Mr. Pakiwala and all these big important cases. But did you, of course, obviously you handled cases on your own during that time. Did you do a lot of trials then as a young advocate yourself?
Way back in 1980s, we used to do trials, and trials had become the big trials had all got delayed. Only the small trials used to go on. We used to get these small dockets from law firms saying go do the small trials. So that's way back in 1980. For a year or two, we did trials. After which,
Was that
unfortunately,
important? Sorry, was that important for your development as an advocate? Doing this, although these small matters, you just take it and run.
I realized in 1980, 81, and in India, we believe in inheriting certain attributes from your ancestors. My grandfather was known for cross examination. For him, they used to say he could get a witness to say what he wanted him to say. So I realized I loved cross-examining witnesses. I would, and it's very hard work. You know, the most difficult part of any case. Arguing law is easy. Arguing in a court of appeal is easy, but the at the grassroots, when you're cross-examining a witness, that's when you lay the foundation for your case. I used to love that, and that's one thing which I had started missing. It was great fun doing constitutional law and administrative law and commercial law at a higher level. But somewhere in India, till about 10 years ago, we virtually did not have trials because there was such a backup in the courts that everything was resolved at interlocutory stages. It's only 10 years back, 7, 8 years back, that we outsourced, and that's made a huge difference. It has speeded up work, but it has changed the nature of work. Now evidence is recorded by a commissioner outside the court in India.
Oh, I see.
So you're never before a judge cross-examining a witness. It somehow loses its zing. You know, the joy of cornering a witness, that goes away. That's why in early
Yes.
2000 I started doing more and more arbitrations where you at least had full-scale trials. That was the shift to the arbitration practice.
Could I ask, in terms of your preparation for, say, an arbitration or a commercial case in the High Court, is there any difference in how you approach a case, or is it essentially the same?
Hugely different. I did an appeal in the Court of Appeal. Very interesting question under family law. I'm just giving you two recent examples, which was 1 full day's hearing, 1.5 days preparation, and 2 hours to write the skeleton. Very interesting question of law, but much easier to digest. I just finished a four-day arbitration before a very senior tribunal, and I had to cross-examine only one witness. The documents were, of course, fairly large. We had about 12 ring folders of documents. Took 3 weeks of preparation, that one cross-examination. That's the difference.
That's the difference. Mr. Salve, sorry, if you can just turn back your career back in India. I know now you practice primarily in the UK. You became Solicitor General. For those of us who don't know this, what's the difference between being an SG, a Solicitor General, and AG in India?
Well, actually, there isn't that much difference in the sense, unlike the UK, the Solicitor General and the Attorney General are in court every day. The Attorney General does much less contentious work in court because the Attorney General is more involved in adversary work. There's a lot of adversary work which comes, all Prime Minister's office opinions come straight to the AG's office. I was very privileged as SG. The Prime Minister had so much faith that many times important cases would come my way directly. The Solicitor General in India is in court 5 days a week. He is in the Supreme Court, he is in the High Court, and as Solicitor General, I had my plate overflowing, not just full, with contentious work in court. And you have to do all kinds of work. And for example, I had to, on one occasion, take on a very big criminal appeal in the Supreme Court arising out of the stock scam. And I had very little criminal law practice. I
Yes.
had done 1 or 2 small criminal trials. And my Attorney General called me and said, this is very important. The Central Bureau of the Federal Police, the Central Bureau of Investigation is very keen. We have Mr. Ram Jethmalani, God bless him. He was one of the tallest criminal lawyers. And it's the first appeal in the Supreme Court arising out of the stock scam convictions. They want you. And I said, me? It's just 7 fat volumes of evidence. When is the case? He says 5 days from now. Oh, thank you very much. So, as Solicitor General in criminal law, I always says I learnt swimming in a deep, choppy sea.
Sorry, Mr. Salve, could I just ask? I mean, I know we're laughing at this, but really, when you are faced with that at that time, all these fat volumes of documents on an area which you are not an expert in. You got 5 days to prepare. I mean, how do you do it? I mean, do you just like, okay, forego sleep and just hit the books? How do you organize your structure?
Two things. Fortunately, I had a very fine team of public prosecutors who had conducted the case. The investigating officers of our team, they were the senior most from the bureau, and they knew every page of the record by heart. So he sat down with me and he says, "Sir, don't worry. Out of this, I will show you what is going to be key. I know exactly what Mr. Jetmalani will argue. We have faced him before. This is what he's going to argue. These are the points you need to focus on." And he was spot on. And ultimately, in the Supreme Court, it boiled down to 4 or 5 important issues, most of which were legal issues. And I was very gratified
I
when
see.
we won.
As Solicitor General, were you ever in a position to advise the government then that, because I imagine cases come to you already argued, right? You're taking it at the highest level. Were you ever in a position where you had to tell the government, this is not what I think we should do, we should not fight it, something like that?
Oh, now that it's so much time has gone by, I can take liberties with the Official Secrets Act and give you a few details. So once it used to happen many times, and I must say I had enormous support from the government. I was once sitting in court, waiting for my case to reach. It was a very senior judge who later became Chief Justice Bombay and then a Supreme Court judge. He was that time presiding over a bench of the Delhi High Court. It was a challenge to a customs or excise notification. He looked at me and he says, "Mr. Salve, you know the subject so well because taxation has been my primary forte." He says, "Read this and tell us honestly what you think about it." So I got up and I read it and I said, What I think about it is that this case calls for an adjournment. Give me a week's time." I I went back and I wrote a letter to the chairman of the Central Board of Excise and Customs saying, "You must withdraw the circular straight away. It is completely illegal." And I gave a paragraph of reasons. The Central Board of Excise and Customs chairman made a noting in the file saying, "Who instructed the Solicitor General to appear in this case?" When I got that, I sent in a resignation to the law minister saying, if
Oh,
the Solicitor General cannot answer a court when asked on an important question, then I don't think this office is worth holding. I knew how close I was to the government. Of course, half an hour later, the finance secretary called me up and said, "I need an appointment and I need it now." He came with me and he says, "First of all, unconditional apologies." He brought the CBEC chairman with me and he says, "Big mistake. Sorry, we have no idea. We'll never do it again." I said, "It's okay." He fixed up a meeting next day. All the revenue officials came. And I told them what you've done is wrong. And we had a 1.5 hour brainstorming. And I told them, "Sorry, I don't think with you like this. So I don't agree." He said, "Fine." They withdrew the circular. So, and I can multiply these incidents on so many occasions. I've told the government, "I think we've got it wrong." They said, "Well, if you say we've got it wrong, we've got it wrong. Say so."
so there was, I suppose, at the end of the day, although there may be some civil servants or ministers or politicians who disagree with you, but ultimately, when it comes to it, the persons with the real authority will always accept your view then as SG, right?
Yes, I can tell you the 3 years in government which I've had was so gratifying because we always brainstormed. We always and it reached a point where the government respected me hugely. I remember in 2002 we had this big problem about first we had the earthquake in Gujarat, if you remember, then we had riots in Gujarat. And the question was whether
Mhm.
the elections should
That's right.
be deferred or not be deferred. And the Prime Minister and the Home Minister, the Deputy Prime Minister, called me for a meeting straight and they asked me what. I told them, "I realize your difficulties. And the correct way forward for the government is not to do this or do that or to make comments. The correct way is get a presidential reference. We have a power of taking the opinion of the Supreme Court." They said, "Done." The Prime Minister, in my presence, called up the Cabinet Secretary and said, summon a Cabinet meeting for tomorrow afternoon. And he told me, you have to draft the questions. So I went back and he says, you realize the confidentiality? I said, yes. So I dictated them into my laptop, made a single copy. I was invited to the Cabinet meeting, presented it. They had a look at the questions. The Cabinet passed the questions. I went back, I chiseled them further, called the law secretary and said, this is one single copy. It's not leaking from my office. If this leaks, you're responsible. He said, sir, don't worry. He took that, he put his stamp, and it went straight to the president's house. And it was for the first time a presidential reference became public knowledge after the president's house issued a press release.
Not before.
Not before.
But this is the kind of respect. This is the kind of respect which the government had for its Solicitor General. I think it speaks volumes for the government.
That's right. Mr. Salve, you were a Solicitor General for 3 years. Then you went back and you left in 2002. Was it difficult to return to private practice after being SG and doing all these cases, having the ears of prime ministers and ministers?
I'll tell you, it's very interesting. Two incidents. One is this happened, and then there was some minorities case going on, and I just finished. There was some controversy. So anyway, I resigned. I left, and my daughter was studying in the UK. She was unwell. We had a week off. I went there, and I'm 3 years away from work. So I was wondering, come back to private practice. It'll take a few months. In the meanwhile, my office was the government office, and the day I resigned, that day I moved out of the government office accommodation. So I was talking to my wife. I said, yeah, I don't know where I'm going to work. I don't know how things are going to be. And I said, anyway, let's go spend a week in UK, come back, and then think of work. So fourth or fifth day on my vacation, I called my clerk and I said, the court was on a 1 week break. I said, do you have any work for coming back? He said, yes, on the reopening day, we have 35 cases. I said, listen, I can't do 35 cases. Increase the fee. So he increased the fee. He says, it is still left for 25 cases. I said, okay, return 2/3 at least. I was gratified. I said, it's going to be a soft landing. And I've never looked back. But I must say, for the next few months, every time there was a dinner at the Prime Minister's house where there was an occasion, if the Chief Justice was retiring, I was invited for the dinner, or if there was some such thing, I was invited. Twice the government called me in to consult me. The big government arbitration at that time against Enron, I was asked to lead. So it was a soft landing after coming out.
I see. Right. Mr. Salve, could I just ask you about a couple of your more well-known cases, in particular the Vodafone case, because famously you, in order to prepare for the appeal, you went to stay in England, in the UK for 3 months. May I just ask, what is the thought process there? Why do you actually needed a complete change of scenery to prepare for this case?
In India, we don't have, one of the things which I find works better for me is the way we work in the UK. You have a big case. When you do that big case, you don't do anything else. Now, that unfortunately is not the culture of eminent senior counsel in India. They have so many balls in the air at any one particular point of time. To be able to argue Vodafone with its multiple dimensions, I wanted, A, it was a large record. B, I wanted to be able to think and brainstorm, work by myself, work with the teams for 2 to 3 weeks, 4 weeks, 5 weeks, without any disturbance. Now, if you're in India, it becomes very difficult if somebody says, oh, I have this small little case, it'll take only 1 hour. Come on, you can't do it for 1 hour. People don't realize it breaks your chain of thought. When you're deep into a case, day 5 you think of a point, or day 6 you think of a point which you don't do on day 5. If in between you do something else, that chain is broken. So that is why I used to do all this. And for 9 weeks, I argued Vodafone. The Vodafone case lasted 9 weeks. In those 9 weeks, I did not do anything, not even a single meeting. other than Vodafone. If the court would not take Vodafone on Mondays and Fridays, we used to spend Mondays and Fridays preparing that, not doing other admission cases. So that's how that works for me. Maybe I have a narrow intellect. Maybe my mind is not as powerful as it is for others. I can't deal with when you're doing a case of that size and magnitude. You can't juggle around, and that's why I work like that.
This episode of Advocates, the podcast, is supported by Taylor's Law School, where you get to learn about law and justice. Explore how these top advocates battle injustice as they tell us their stories.
Mr. Salve, apart from that Vodafone case, of course, you did other huge commercial cases, but could I just turn away from that aspect of the law to some of the, I suppose, human rights stuff that you did? You actually represented, I hope I get his name right, Kulbhushan Jadhav in the International Court of Justice. I mean, this man was fighting for his life. Could I ask, before you did the Jadhav case, did you ever do a case where somebody's life was on the line?
I've done a lot of cases in India pro bono where people's lives are on the line. As early as 1983 or 84, there was a challenge to what was called the Assam emergency law. You know, the northeastern states that time were in a difficult situation, and there was a
Yes, that's right.
emergency powers law which was challenged, the constitutional validity of which was challenged. The petitions got transferred to Delhi High Court because they felt the situation at Assam was such the case could not be heard there. Pro bono case, I was asked to appear. I appeared. Right from there onwards, I've done so much work. And in recent times, a group of NGOs brought this young girl to me, and her family had been killed in the Gujarat riots. And the police had filed a report saying, yes, there is a crime committed, nothing we can do. They brought her to me. I filed a petition directly in the Supreme Court. The CBI went, conducted an inquiry, and ultimately, policemen, doctors, and the assailants were all sent to jail. Conversely, I have done bail cases. I've done one of the cases which I enjoyed arguing the most, and I think we had a good result, was the compulsory narco analysis. You know, there is a process by which you inject narcotics at the investigation stage to get a person to talk. And the question was whether you could do it forcibly. And we argued and succeeded, saying that is violating the human's right to his own body and right to privacy. And all this is pro bono work. I got bail for all
Right.
those who were in jail under the Prevention of Terrorism Act for the train burning incident in Gujarat. So I've done a lot of pro bono work. Kulbhushan Yadav, I appeared actually for the government of India. As you know, in the ICJ, it is government versus government.
That's right.
And that started on a very, very different note. There was a lot of agitation in the Indian media about his conviction. So one of the media channels came to me and I made an offhanded comment saying, I'm sure there are remedies in the International Court of Justice which can be explored. 2 days later, I got a call from the External Affairs Minister's office. The External Affairs Minister I knew very well personally. I'd worked with her as Solicitor General, and she was a very powerful External Affairs Minister, late Mrs. Swaraj. And she was more like family to me. So she called me and said, "You shot your mouth off on TV. You said something. It got picked up in the Prime Minister's office, and now come and find a way out for us." I said, "Oh my God!" So I went to her office, but her team, my team, we worked on it. We found there was a violation of the Vienna Convention on Consular Relations. So we developed the case from there, and that's how we managed to get in. That the first, in fact, we said whether we win or we lose, we need to save the man's life. So we first went, we got provisional measures for 1 year. And we said, maybe, in that 1 year through diplomatic back channels, we may be able to work something out. Didn't work. So we went for a final hearing and we had a good result.
Mr. Salve, could I ask, all these big, huge commercial matters that you do, tax cases that you do, Gopal, Misha and I, we are primarily civil and commercial lawyers ourselves. But over and above that, you do all these other human rights cases and like you say, all these pro bono cases. Is there a difference in the approach that you take? That's number one. And number two, do you feel a different sense of pressure I mean, acting for Mukesh, the Ambani brothers, for instance, one of their cases, and fighting for somebody's bail application, liberty of subject and all that. Do you feel a different sort of pressure?
When you get a good result in a good civil dispute, whether an arbitration award or a Supreme Court judgment or a trial court judgment, it gives you great satisfaction, great intellectual joy. You feel you've got the better of another good QC on the other side, and you got the better of the situation. But you feel a very different sense of warmth. I got bail for one person, and when I came out of court, he came to me, folded hands, and he says, I go to this Sufi mosque in Delhi, sir. And I had gone and prayed, and he gave me this little, small little tablet. He said, this little thing was what the priest gave me. He said, I didn't have the courage to give you because you're not a Muslim. But I want to tell you, I said, look, I believe in all faiths and all religions, and anything which is sacred to human beings. I said, please give it to me. I will cherish it always. And that little thing I have cherished always. I still have it with me. So, that pleasure, I think that fee which I got was more than any fee which Mukesh has ever given me.
To me, I think there's a very strong human element in all your pro bono cases. But correct me if I'm wrong, but I think you get a lot more cases than you can do, requests to help. And how do you decide, which you can?
That's a tough one, Michelle. You're absolutely right. And, it's with a heavy heart that you turn down requests because I get so many emails saying, my mother is ill and her house is this, or so and so is in jail, and it's been 2 years, we are not getting bail. And I have a lot of youngsters who trained with me in India many times, and they're doing very well. Two of them have become silks. I mean, two of them are judges in the High Court, so they can't do anything, but two of them have become silks. So I always try and recruit them and say, so and so will help you. But yes, there is a feeling that there's so much more one wishes one could do, but I feel life has moved on, so one has to accept the limitations of time, limitations of age, both.
Mr. Salve, you of course now practice in England. You are Queen's Counsel there. You obviously as well still have a very, very active practice in India. Is there any difference in the style of advocacy? Say you're doing an important commercial matter in England, oppression of minority shareholders and all that in English court vis-a-vis a matter before the Delhi High Court.
The law is the same in so many respects. That's why it made it easy to transition. In fact, I recently argued a very big commercial case in India, the Tata versus Mistry dispute. Except one or two cases, all the cases we cited were all English cases. So, because oppression and minority is a notion which was born in the United Kingdom in the old courts, and it has chiseled here. Our law has changed, their law has changed, but there's still huge amount of similarities. So the style of advocacy is very different. Here it has become much more regimented, much more gentler, but one has to do what is also called a emotional transition. In India, it's a lot more passionate. There's a lot more table thumping and aggression. Here it has to be a lot more British, businesslike, gentle.
As fellow Asians, I must confess, I do enjoy the table thumping. Do you feel personally yourself when you transition over to England, you had to dial down the aggression and
See,
and the
I get
drama
my
and the flair?
I get my fill, I get my fix once in a while doing a case in India, and then come back and be civilized again.
When we were on the difference between India and the UK, what about the judges? I mean, do you feel they respond to different things?
See, it's very interesting that you asked that question. Judges are the same all over the world. And the reason is, especially we're not talking of the outliers, to use an expression which we in arbitration practice use. We are talking of mainstream, good, intellectually robust judges. Their approach may be different. The judges in the UK come after a very strong exposure, especially a lot of commercial judges come up the UK, the London ladder, have had large exposure to commercial work, large exposure to international work. You know, in UK, more than 50% litigation has no British person here. It's two foreigners fighting in the UK courts. So the judges here are far more global in their approach and far more liberal in their approach. That's an advantage peculiar to this country. Other than Singapore, I don't have any experience of Malaysian courts, but other than Singapore courts, I have not seen this, because Singapore again has hardly any local litigation. It's all global litigation, global companies, and international flair.
Mm.
This is coming into India. So I see this in the high courts amongst the younger judges who are sitting in the commercial court, where in Delhi and in Bombay, I don't know about the Chennai and Calcutta, but in Delhi and Bombay, which are two very big commercial law centers today, judges are turning international. But it will take time for this to filter up to Supreme Court. Supreme Court judges are open-minded, but they've not had the exposure to that kind of hardcore commercial law, and their exposure is more to constitutional law approach. I can give you a very interesting example of the difference. We were sitting in a moot court, and there was Justice Sikri, who's retired, very well-known person from Supreme Court, very, very good judge. He was the chair of the moot court. I was there, and there was a Singapore, I'm forgetting who it was, one of the top Singaporean commercial lawyers as the third judge. And that poor student was arguing on the construction of a contract. And Justice Sikri's immediate question was, but that's not fair. And I looked at that Singaporean judge, he looked at me and he went,
Oh, that's not fair.
see, whereas here, the first thing I did in arbitration with Sir Christopher Stoughton as our chair. And he started by saying, Harish, you must remember, the common law is red in tooth and claw. You know, if we leave it to the parties to draft their contract, we only try and understand its English. So whereas a constitutional judge will always say, is this fair? Now, this is this fair is not a question you ask in commercial.
That's right. Could I ask, Mr. Salve, on that note, because you are not just a commercial lawyer, you cut your teeth in lots and lots of important constitutional case. So when you are now faced with a commercial matter in front of you, how do you divorce yourself from that particular mindset?
You have to remind yourself that what you're doing is reading a contract, and you're not persuading a judge that, see, there is a general rule of advocacy which I strongly believe in. Before you win a judge's head, you have to win his heart. Every judge will strain to do something which he in his heart perceives to be injustice. If he is driven to it by contract, he will, but he will try and strain on the leash. With that overarching consideration in mind, you have to remember this is commercial law. This is a contract. If it is the exercise of a call option, and as Lord Hoffman said, if the contract says it has to be on blue paper, it is not for you to ask why is it. How does it matter if it's on pink paper? That's the contract. In constitutional law, you would say we have to give it a sensible interpretation, as long as there is no prejudice caused. Now, many times in commercial law, you don't ask the prejudice question. And in one area where I'll show you the difference which bumps up in England versus India, the law is exactly the same, for example, on liquidated damages. Damages can't be punitive as common ground.
Mm-hmm.
But how readily will an Indian judge start looking at a challenge to liquidated damages on the ground it's punitive? He will do so readily. An English judge will do will get dragged into that, kicking and screaming, saying, "No, this is not my job." Unless you make out a really facially obnoxious case, he will not go behind liquidated damages. Indian judges have to be reminded over and over again, look, you are not drafting this contract. Parties have agreed to this, right?
Mr. Salve, that is a brilliant point. We have similar issues back home in Malaysia too. That's clear.
Could we ask you a little bit about your move to the UK, Mr. Salve? What prompted that? It's quite you had two big changes from accounting to law and then law in India to the UK.
Yeah, the move to UK was actually predicated from what started happening from 2006, 2007. I did a lot of arbitrations after 2005. So half the time, I mean, most of the arbitrations are outside India. It's either Geneva, Paris, Singapore. I came to Singapore a lot, UK. I started enjoying international work, and also 50 plus, as my father predicted, I did get bored of the same in and out of court. So this was a refreshing change.
Yeah.
And then 2006-7, when Vodafone happened, during the Vodafone 5 years of Vodafone, there was a lot of. I stayed here a lot. I had bought a flat here way back in. I rented a flat first for my daughter in 2004. We continued to live there, which I bought recently. So I had a flat here in London. We used to start spending. Summer vacations were here, which was 2.5, 3 months. October vacations were here, and then in between I was here for work. So I suddenly realized I was spending 5.5 months in London in any case. And then I started working here. So it sort of grew organically. And then in 2011-12, I did some big arbitrations for SR, where I worked with two QCs, with a QC from Blackstones Chambers. And by which time, when I used to come to London, I used to work either Freshfields, my friend was a partner, he used to give me a room, or I used to go and work in 51 Buckingham Gate, the Tata Hotel. So my friends told me, why do you go there? Why don't you come to Blackstone Chambers? So I came and met the then heads of chambers, and they said, yes, you come and you work here. And then we have a very persuasive head clerk who said, why don't you write a letter? They will admit you to the bar. I said, I'm too old to take exams. He says, you first write a letter, then we'll see. I wrote a letter. I got admission to the English bar. In 2013, I moved here.
You said the growth was organic, and in that sense, it was. But in terms of your practice in India, how do you tell your clients and your partners in India that you're moving away? And how did they feel about that?
So my tradition. I trained in Mr. Sorabji's chambers, who came from Mumbai, and he came from the Bombay system. Now, Bombay was the old British practice of the sharp divide between the solicitors and the barristers. So I have never had,
I see.
in that sense, a client. I have never filed a case in court. I don't know where the registry offices are. I don't know how to file. If I may review a pleading, when I was young, I used to draft a pleading and then give it back to the solicitor, who would do all the filing and send me the brief for arguing the case. So in that sense, I've never had a problem. I've never had a partner. I used to have juniors who were in and out my chambers and followed the same rule. Later on, I used to give them a little stipend. But other than that, many times they got instructed with me in important cases. So they were directly paid fees by the client and the solicitor. So that's how I ran my practice. So, I mean, people still want me in India. I still go there when there was physical work, And now everything is a commute. I get into a plane here at night. Next morning, I'm in India. The day after, I'm in court. I've done some silly things like in between a hearing here with a 2-day break, I've gotten to a plane, reached there in the morning, in the court in the afternoon, back in a plane at night, and back here in court next morning. So,
Oh, wow.
My goodness.
not a very clever thing to do, but I've had to do it at times. So,
do you prefer it now when everything is virtual?
it makes, I miss the in-person hearings, but at least it saved me a lot of travel time to India. Of course, right now I'm really regretting not being able to go to India, not because of any work, but because 10 days ago I became a grandfather for the first time.
Oh, yes.
Thank you.
Congratulations.
Congratulations, Mr. Salve.
Your daughter or son
My
is in
daughter
India.
had a child
Mm,
whom I've only seen
wow.
on FaceTime.
Right. Right.
Um,
Hopefully,
I know.
the
yeah.
situation will improve.
Mr. Salve, this is something I personally must ask because I think it's so rare for someone to appear in the ICJ. Very, very unusual experience. Could you tell us and our listeners a little more about how that works?
Oh, it was a most educative experience, and I've done it twice, not once. The
Ah,
Colbushan case became famous. Before that, I did another case which didn't pick up media interest. Action was brought by Marshall Islands against Britain, Pakistan, and India to stop their nuclear program. And we had a whole group of American academics and lawyers who were appearing for Marshall Islands. And I appeared for, of course, I appeared for India. And on both occasions, it was fascinating working with the Ministry of External Affairs. You know, the form of address, the way it's in language of diplomacy, where you use very gentle language, you put your point across. There, the literature is fascinating. I love public international law literature, and it was such a refreshing change to discover the nuances of public international law. The problem is you have to give a written speech. So your speech has to be in writing and delivered to them half an hour before the court begins, an hour before the court begins, because there are translators and there has to be simultaneous translation. So they want to read your script and realize what you have to do is, and if you're given 1.5 hours, it means 90 minutes, not 91. So you have to finish your speech in 90 minutes. So I had to, when my final draft was ready, then I read it. It took 93 minutes. So I had to remove something. Then I read it. And remove something. Then I read it. So practicing reading a written draft to finish it in a time frame was very interesting. No,
Was that your
there's no
normal
other
style
court.
of
There's no
advocacy
other court
in
which
other
does this.
cases? Or
Here
yeah.
we give a skeleton and you sort of round up your submissions. You touch the key points there. You are virtually supposed to read your speech. And in a lighter vein, as I said, the big challenge then is keeping the 11 or 14 or 16, as many of them are sitting. The big challenge is keeping them awake
Mhm.
when you're reading a written speech.
That's right. That's right. Mr. Salve, you don't struck me as a person who I actually, there are some cross-examiners who actually writes questions in advance, or there's some people who submits and puts it all that nicely. You sounds to me, at least as an advocate, who has certain key points and just goes on there extempore, so to speak. Is that how you normally approach submitting before a court?
Cross-examination, of course, you have to write down questions where the documentation is large so that your cross-reference is ready.
That's right.
But for court work, for me, writing something is very difficult because my best performance is extempore. And it is not unusual. In fact, even in the arbitration, there is something, and the other side lawyer made a point. And when I was replying, I suddenly noticed a clause in the contract which gave a completely different light. And I developed it. And in fact, the instructing solicitor said, "You made that point. We never discussed it before." I said, "No, we didn't." It came to me at 5:45 in the morning when I was scribbling down some points for reply. So extempore is the way which we were taught advocacy, and I think that works the best. It comes from your heart, and in extempore you connect with the judge. So you are saying what you're answering him, you're addressing him, you're seeing where he's going, you're modulating your argument. If you follow a written script, many times you develop a disconnect and then you're just sort of going off in different directions. The judge is thinking of something and you're saying something else.
That's right. So, Mr. Salve, I just have some quick questions for you. First question: if there's a case you could go back in time and re-argue, what would that case be?
The bearer bonds case. I argued that in 1981, when I was a raw junior, straight out of this, by my senior didn't show up. He got stuck somewhere. I was asked to argue. There are so many more points I could have made.
Good
But
Lord.
my problem was 1.5 years at the bar, addressing 5 judges of the Supreme Court. For the first 5 minutes, I couldn't find
Wow.
my voice. And I had so many nice points written down, which I just couldn't make.
Was that terrifying? That particular experience.
It was, by the time I got to rejoining, I actually developed a fever. And I called a doctor friend and said, I got a fever. He says, just panic. He says, you don't need a paracetamol. You need a compose. Go to sleep or have 2 whiskeys. Go to sleep. Next morning, you'll be fine. And he was right. I was fine next morning.
What do you enjoy most in practice? The interpersonal skills or the intellectual
I
exercise involved?
actually enjoy the interpersonal skills, the joy of the joy of oral advocacy.
Hmm. The opponent you respected most.
Very, very difficult to say. Very difficult to say.
Who did you learn most from?
Surprisingly, I mean, I have back in the day learned a lot from eminent seniors, but I think now I learn the most from younger members of the bar who I feel are so talented, so full of ideas. I feel if I can take their exuberance, their enthusiasm, temper it with a little bit of maturity, I produce much better work than I do by trying to think with my somewhat weary brain.
Mr. Salve, the judge who challenged you the most?
Oh, the judge who challenged me the most. I've had some very tough judges in arbitration. I've had some tough Bill Rowley, who's a friend, but very tough arbitrator. I've had Lord Hoffman appearing before him, and he has this way of looking at you.
Hmm.
And or if he starts looking at his iPad, you know you've lost him. Yeah. In India, we have
Oh.
had some very strong judges, very, very intellectually powerful judges who it was a pleasure appearing before and who challenged me. Justice Chandrachud, for example, or Justice Nariman. You know, they're intellectually very, very
Mhm.
sparkling minds.
Mm.
So they are the ones who challenge you the most.
What cases have you argued that stand out for you? Maybe top 3.
The top 3 cases which I have argued are cases which will be of very, which gave me great satisfaction, are cases which may not be of that great, except one maybe. I think my finest performance as a tax lawyer was Vodafone, unquestionably, because it was so bristling with legal issues. The finest case I have argued in human rights was the narcotics case, where we persuaded the court that this narco analysis cannot be made, cannot be forced, because the kind of human rights issues which arose were beautiful. And I have done a lot of environment law. And one of my most learning experiences was
Oh.
an amicus curiae assisting the Supreme Court. We have introduced this notion, which was mooted by some environmentalists in the US. It's called the net present value of change in changing environment. So, if
Ah.
in our forests, if you they calculated what's the ecological cost of removing a tree, and you try and quantify it, it's a very complex mathematical empirical model, and you virtually develop an algorithm, and on that basis a value per hectare is fixed of removal for forest, and persuading the court to accept that as a principle and getting the Supreme Court to hold that as a right, as a constitutional right to protect the environment. Anybody who removes an Indian forest has to pay net present value. Now, this is not something which is well known, but to me, it was such tremendous intellectual satisfaction. Understanding it, it's a completely new subject, understanding that subject and working on it.
Mr. Salve, what do you think is the most important quality in an advocate?
The single most important quality in an advocate is an open mind. Don't ever get obsessed by your case. The strength of your case is the strength of your weakest point. If you cannot spot that and address it adequately, you're running a case with a landmine in it to blow up at any time in your face.
Lastly, could you describe a typical day at the bar today? I suppose.
Oh, today, typical day at the bar is here, 60% or 70% of your time is in chambers, only 30% time is in advocacy. So in the real world, before we all became Zoom addicts, typical day at the bar was
Yes.
coming to chambers at 8:30, getting the first cup of coffee and start reading or getting ready for conferences. And if you're in court, the typical day at the bar is again reaching chambers at 8 o'clock, getting dressed, walking with the team across the street. It's so beautiful. You walk across the street, and of course, lovely London weather. Every time if you're in court clothes, it must rain. So remembering to carry your umbrella and walking across, especially for us, walking across down Fetter Lane, going into the Rolls building, going into the courts. I love that. I just love that. Or walking across to the IDRC, where most of the arbitrations are conducted. So that's a typical day.
Is it the same routine if you were back home in India?
India, the same routine. I would be in my office at about 8 o'clock, 7:30, quarter to 8. In court at 10. India, we did court 5 days a week, a little too much. Come back at 4 o'clock, have a shower, and get back to work till about 7:30. Long days, but you work about the same here, but there's a lot more satisfaction of doing less work with greater intensity.
Less work with greater intensity. Final question. Could you just develop on that point? What do you mean by less work but greater intensity?
So if you have lesser number of briefs, but the intensity with which your mind works on each one of them, and the amount of time, the amount of thought you pour into each one of them, your client should feel, if you're a lawyer who he has hired, and especially if he's paying you a good fee, your client should always go out feeling for every £100 he paid you, he got £150 worth.
Right. Mr. Salve, that's absolutely brilliant, utterly fascinating. But could I end by just asking about a piece of gossip? Is it true that your client, Mr. Ambani, brought you a whole set of outfits and clothes just when you were fighting his brother?
Mr. Ambani has not even bought me a handkerchief. I told Mr. Ambani,
Okay.
I took that article and said, how about this? He says, yes, Harish, we have bought Brooks Brothers to India. So he sent the Brooks Brothers fellow. I thought, yes,
Right.
Mr. Ambani living up to the gossip story. I went and ordered suits. And 2 weeks later came the invoice. No, Mr. Ambani has been a dear friend. He's a very generous friend. He's a very dear friend. But he still hasn't bought me the wardrobe.
You never got a wardrobe off him. Mr. Salve, thank you so much. It's brilliant. Michelle, do you have any closing questions for Mr. Salve?
Oh, no closing questions, and thank you so much.
Thank you for listening to Advocates, the podcast. If you enjoyed this episode, be sure to follow us on all our social media channels. Leave a review or share this episode and tag us. We'd love to hear your feedback. Thank you.
Listen to the voices of the advocate.